Welcome to Juris Stupidity, a video podcast dedicated to the use and misuse of legal terms and concepts in social and other media. This podcast is about hearsay. Recently, some of you may have been watching the nationally televised hearings in Georgia where a prosecutor and a legal contractor were accused of misconduct. During the questioning of witnesses, there was a frequent objection that the answer called for the witness to testify to hearsay. Variously, those objections were sustained or overruled. And that even shows the lawyers sometimes got it wrong, at least according to the presiding judge. So, just what is hearsay? It is, quote, a statement or other than the one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted, end of quote. Said another way, it is a statement set out of court that is offered to prove something is true or false. A recitation of the whole rule against hearsay can be found at Federal Rules of Evidence 801 through 803, rules that most state courts generally follow. There are 23 exceptions to the rule against hearsay, and I won't address them here today. They're all laid out in Federal Rule of Evidence 803. See for yourself. However, here I will point out two kinds of statements that are not hearsay at all. They are, one, a prior statement by a witness, or two, an admission of a party opponent. Well, the first one is self-explanatory. The second one, party admission, deserves some discussion. There are 5 such types of admission, and they can be found in Federal Rule of Evidence 801D2. Basically, if a party, plaintiff or defendant, says something or does something expressive out of court that is relevant to the litigation, it can be admitted into evidence. Accordingly, when you are following any of these many high-profile cases that are in the media today, if one of the parties says or does something expressive out of court, say on TV or on other media, it is potentially admissible as evidence in the party's own case. Not just anything on TV or otherwise by anyone else, but what the party says or does. So if you see a party in a case say something contrary in the media, it is likely admissible as a party admission and not blocked by the hearsay rule. Got that?